Welcome to POMpod, the Peace of Mind podcast. I'm Travis from Gasper Law in Texas. Each week, we break down estate planning in plain English so you can protect yourself and the people you love with clarity and confidence. Let me ask you a question. If you couldn't speak for yourself tomorrow because of an accident, an illness, or a medical emergency, who would be making decisions for you? Not who you hope would step in, not who feels closest to you emotionally. Who would actually have the legal authority to do that? Most people don't realize this, but in Texas, and really in most states, it's not automatic, even if you're married. And today, we're talking about the documents that protect you before you die. Because estate planning isn't just about death, it's about life, dignity, and clarity during really hard moments. Today's episode is all about incapacity planning. This is the part of estate planning that people tend to avoid, not because it's complicated, but because it asks us to imagine situations we'd rather not think about. But here's the reframe I want you to hold on to throughout this episode. Planning for incapacity is one of the most loving things you can do for yourself and for the people who care about you. It's not pessimistic, it's practical, and it prevents confusion, conflict, and court involvement when emotions are already running high. When we hear the word incapacity, we often imagine something permanent, but legally, incapacity can be temporary. It can look like being unconscious after an accident, being sedated during surgery, experiencing a stroke or serious illness, or certain mental health crises. Incapacity simply means you can't make or communicate decisions for yourself, even if that's only for a short time. And when that happens, someone has to step in. The question is whether you chose that person or whether the system does. This is one of the biggest misconceptions I hear. I'm married. My spouse can just make decisions for me. In Texas, that's not automatically true. Without the right legal documents, your spouse may not be able to talk to doctors. They may not be able to access financial accounts. They may not be able to manage bills or sign paperwork. Instead, they may have to go to court to ask for permission. Court is public, expensive, slow, and emotionally exhausting, all during a moment when your family just wants to focus on your care. So let's talk about the core incapacity planning documents I recommend for most adults in Texas. These are foundational, whether or not you have a will or trust yet. We'll cover medical power of attorney, HIPAA authorization, advance directive, sometimes called a living will, and financial power of attorney. A medical power of attorney lets you name someone to make medical decisions for you if you can't. That includes talking to doctors, consenting to treatment, making medical choices on your behalf. This person is often a spouse or partner, but it doesn't have to be. This document is especially important for unmarried couples, LGBTQ+ families, people who rely on chosen family. Without it, even the most loving partner can be legally shut out. Important clarification. This document does not take away your rights. It only activates if doctors determine you can't decide for yourself, and it ends once you regain capacity. You remain in control. HIPAA is the federal law that protects your medical privacy. That's a good thing until it prevents the people you trust from getting updates or information. A HIPAA authorization allows you to name people who can receive medical information, speak with healthcare providers, stay informed about your condition. Think of this document as answering the question, Who's allowed to be in the loop? An advance directive, often called a living will, answers one specific question. What do you want if you're facing a terminal condition or irreversible illness? This document guides doctors, reduces guilt and second guessing for loved ones, brings clarity during emotionally heavy moments. It's not about giving up, it's about giving guidance. And this isn't permanent. You can update this document as your life, health, or values change. A financial power of attorney allows someone you trust to handle financial matters for you if you can't. This can include paying bills, managing bank accounts, handling insurance issues, managing real estate. Without this document, even a spouse may have no authority over accounts titled only in your name. Two important things to know. This power can be immediate or springing, meaning it only activates if you're incapacitated. You control how broad or limited the authority is. This isn't about handing over control, it's about preventing financial chaos during an emergency. Each of these documents does something different, but together they create a safety net. They reduce confusion, avoid court involvement, protect your dignity, and make things easier for the people who love you. Whether incapacity lasts hours, weeks, or longer, these documents matter. If you are over 18, married or unmarried, healthy or dealing with medical concerns, a parent or not, you need incapacity planning documents. This isn't about how much money you have, it's about clarity and care. I hear this all the time. I know I need this, I'll get to it later. Life is busy, that's real. But incapacity planning only works if it's done before it's needed. You don't buy insurance after the emergency. This is the same idea. If this episode raised questions, or if you realized you don't have these documents in place, that's okay. You're not behind, you're not failing at adulthood, you're just human. At Gasper Law, we walk clients through this step by step, clearly and without judgment. You can listen to more episodes of POMpod, share this one with someone you trust, or book a peace of mind planning session when you're ready. Estate planning isn't about expecting the worst. It's about making things easier for the people you love. Thanks for listening, and I'll talk to you next week.